Welcome everyone to the Judiciary Committee hearing this Groundhog's Day again. Let's see, 2-minute time limit on testimony both from Zoomers and from people in person, and if we have a catastrophic technical failure, we'll try again on February 6th, which I guess is Tuesday, is that right? Tuesday to February 26th, February 6th at 9:31 a.m. in this room 016. First up today is SB 3174, relating to state tax administration, eliminates an obsolete fee for certified copy of a tax clearance, adds a penalty for failure to comply with other reporting requirements. First up on SB 3174 is Director Suganuma for the Department of Taxation, or his designee. Good morning.
Good morning. Kristen Sakamoto, Deputy Director of Taxation. Thank you for hearing this measure. The department is in support of this administration measure. It will assist in our efforts to improve tax compliance. As you noted, there are 3 main components to this bill. The first would, it really is a kind of a cleanup provision. It would just eliminate the $5 fee for certified copies of tax clearances because we don't offer certified copies, they're not required for the tax clearance. The second provision deals with persons who collect rent on behalf of owners of rental properties, short and long-term rentals. The law requires them to provide a disclosure to the owners, notifying them of their tax obligations, and also requires them to provide the department with information, including the identity of the owner, and in some cases, the amount of taxes collected or the amount of rent provided. Unfortunately, though, there is currently no penalty associated with this provision, so enforcement is difficult. We propose a penalty of $500 per violation, which will assist with tax compliance. The final part of this bill would increase the penalty for unfair competition. Under current law, a taxpayer is prohibited from advertising that GET is not a component of the price to the purchaser. That fine set by the law is $50, which has not been increased since the law was first enacted in 1935. So in order to be more of a deterrent, we propose increasing the fine to $1,000 per violation. I'm here if you have any questions, but thank you for hearing this measure.
Great, thank you. Next up is Tom Yamachika for the Tax Foundation of Hawaii on Zoom, I believe. Good morning.
Morning, Chair and members. Tom Yamachika for Tax Foundation of Hawaii. We'd be happy to stand on our testimony and be available for questions.
Thank you very much. That's everybody who has signed up to testify in SB 3174. Would anyone else like to testify in SB 3174? Seeing none, members, questions? I don't have any questions either. Let's go ahead and move on to the next bill, which is SB 3008. This proposes an amendment to, or amendments to Article 7, Sections 12 and 13 of the Hawaii Constitution to expressly provide that the legislature may authorize the counties to issue tax increment bonds and to exclude tax increment bonds from determinations of the funded debt of the counties. First up on this is Mary Alice Evans and Dean Minakami for the Transit Oriented Development Council.
Arizona on behalf of the TOD Council.
In support? In support, okay. Next we have Michael Formby, Managing Director of City and County, in support. Next we have Tommy Waters, Chair of the City Council, Honolulu, in support. Next we have Ren Tanaka, President of NIOP. In support, okay. Director, were you here to testify on this bill? Please come on up.
Thank you, Chair. Ed Sniffen with Hawaii DOT. We're in support. We just submitted our testimony late. Apologize for that.
Okay, thank you. Next is Tom Yamachika for Tax Foundation of Hawaii. Morning again.
Morning, Chair, Senators. Tom Yamachika for Tax Foundation of Hawaii. We would pretty much stand on a written testimony. The one thing that we wanted to point out is that we are concerned about the exclusion from the constitutional spending ceiling for tax increment financing. We don't see why tax increment bonds should be treated differently from any other debt of the counties. Be happy to answer any questions. Thank you very much for the opportunity to testify.
Thank you. Next is Ryan Andrews, Stadium Manager for DBET Stadium Authority Aloha Stadium, sorry. In support, Stanford Carr for Stanford Carr Development LLC. In support, Jennifer Sabas, Executive Director for Move Oahu Forward, also in support. That's all the written testimony we have on SB 3008. Did I skip somebody? No, okay. Mary Alice Evans for Office of Sustainable Planning and Sustainable Development.
Harrison Root for OPSD, we stand on our testimony.
In support. Okay, thank you. Anyone else wish to testify in SB 3008? Seeing none, members' questions? I think I have a couple. I guess for Mr. Yamachika first. You're still here?
I am. Thank you, Chair.
Great. So your concern was not counting the bonds from this type of financing in the overall debt ceiling for the counties. The language in this bill, I mean, there's a couple of TIF bills out there. Let's see, how's it go here? Basically, what it boils down to is that only the part of the debt that's not being paid for from the TIF itself would count. Do you view that as equally problematic?
Chair, I'm not sure how that computation would be. I mean, I'm not sure how to figure that out. I don't think it's going to be an easy calculation.
Okay. Okay. All right. Thank you, Mr. Ryu. Would you mind coming up? Same question. I mean, I am a little reluctant to effectively raise the debt ceiling, especially if the TIF, if it doesn't work and it turns out that the county is still on the hook for the money, even if the increment isn't the tax that you get from the increment of the value of the property doesn't turn out to be enough to pay for the bond. So so there's two separate questions. One is Mr. Yamachika's question about how do you calculate that? And let's start with that. Is it easy enough to calculate that?
Sure, yeah, for the record, Harrison Rue from OPSD. Yeah, we stand on, we mentioned it in the OPSD testimony, the infrastructure finance and delivery strategy. And for those following online, there's a link to that in our testimony. Our consultants in that report explored, in detail, exactly how TIF would be calculated. And there is some reference in there. They made a strong recommendation based on this is how it's done in most other TIF districts. We're one of only 2 states that don't currently use TIF. So one of the reasons is that it really provides incentives for using TIF to be able to do that. The calculations in determining whether or not to use a TIF, tax increment financing in a specific district are really based on some pretty clear calculations that there will be enough revenue produced or you won't be able to sell those bonds. So
okay,
that's the reasoning why it's calculated separately and removed from the debt exclusion. It provides additional incentives for making TIF work. But we'd be glad to, so you don't have to read that 100-page report. We'd be glad to excerpt and provide the rationale for that to your committee and as well as to the next committees referred
well,
to.
I guess my question is, I guess after the first year, you're going to assume that, when you take the bond out, when you, I'm not using the right technical terms, but when the bond is issued, you're going to assume that the TIF will work and it will pay for itself and it will pay off the bond. But say at what point do you say, okay, it didn't work, and now we have to take the difference of the part that we're have to pay with something other than the TIF proceeds? How does that get added? How do you add that to the debt ceiling at that point?
I'm not sure. I can't answer that right now. I'd have to look into that or ask our consultants for examples. We did not see any any examples in our research of where that actually had to happen, but we'll be glad to ask that of our consultants or look ourselves.
Okay. The other question I had was, yes, thank you, I appreciate that. The other question I had was, this bill is a little bit different than other ones that were introduced on the topic. Let's see if I can. Do you have a preference in terms of SB 3008 versus I think there's two others?
Yeah, our office did author the one in the governor's package 3051. And our initial preferences, of course, is to go with the one that we researched, but we've done some, in the few days that we've had to compare them and have our consultants look at it, we've identified just a few minor differences. I will say that we are in strong support of passing either bill.
Okay.
We're going to live with this one. We don't see red flags, but we do strongly suggest, since I think if I follow your reference, this would be referred to the committee of which the authors of 3008 is the chair. So if there are specific differences, that referral to the next committee would give us a chance to work with them or with you on any refinements. Yeah, our initial thing is that there's actually things in 3008 that may be better than the bill we offered, and there's some things that we think in 3051 that would be a little better than here. Again, no red flags, but we're glad to work with the authors of this bill to look and see if there's any edits to this bill that would be preferable.
Okay. Are you aware of any states that use TIF? I mean, we don't.
Yeah, all
I mean, the states as opposed to counties.
Well, typically it's the states that authorize it. Typically, since you are dealing with property
Real
tax,
property tax,
it's administered by the county or by the cities. Who, some states the city does the property tax.
Okay.
But there's lots of state projects and state-sponsored projects that, working with private developers that do use TIF, and that would be the case like for us, the state as landowners in Eagle Bay.
It's a county-issued bond as opposed to a state-issued bond.
Yeah.
Okay. All right, thank you. Members, other questions? Thanks very much. Moving on to the next bill, which is SB 3029. This makes appropriation for claims against the state. First up on this is Jason Radula for Department of Land and Natural Resources.
Good morning, Chair, Vice Chair, members of the committee. Ryan Knopfler, Department of Land and Natural Resources, first the department stands on its written testimony and support. We're here for any questions.
Okay, thank you. And support. Next is Skylar Cruz, Deputy Attorney General. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. My name is Skylar Cruz, Deputy Attorney General. SB 3029 is the appropriations bill for claims against the state, its agencies, and employees. The bill currently contains 26 claims for a total of $13,277,828.30. Those claims are described in our written testimony attached as Attachment A. We ask that this bill be passed, and I'm happy to answer any questions that the committee may have. Thank you.
Thank you. Next is Keith Hayashi, Superintendent of Education, in support. That's everybody who signed up for SB 3029. Anyone else like to testify in SB 3029? Seeing none. Members, questions? I did have one question for the AG. Do you happen to know where I know there was an arbitration award recently awarded for hazard pay for during the pandemic. Is that going to be coming, will that eventually be a claim against the state, or is that going to be dealt with in a different way?
Chair, I am aware of that issue, that ongoing procedure to get that hazard pay. It's not something that I'm directly involved in. My understanding is that it's not something that would be a part of this bill.
Okay.
It would be a separate bill.
Okay. All right. Thank you.
Thank you.
All right. Thank you. Other questions, members?
Yeah.
Okay. Oh, yes. Senator Bonnie-Mature, go ahead.
So, yeah, it's basically the same thing. So This bill is basically on civil judgments and settlements, right? It doesn't include workers' compensation claims.
That is correct.
Okay, and that may be a different bill or a different request.
That is my understanding. That is correct. So this bill only pertains to settlements and judgments essentially against the state.
Civil.
That's civil, correct. Yes.
Thank you very much.
Thank you. Anyone else?
Other questions, members? If not, thank you very much.
Thank you.
We'll go ahead and move on to the next bill, which is SB 2638 relating to board packets. This requires boards to make available for public inspection board packets if created at the time the board packet is distributed to the board member, but no later than 2 business days before the meeting. Carves out an exception by allowing public testimony to be distributed to board members within 2 business days before the meeting. First up on 2638 is Cheryl Kakazu, Park Director, Office of Information Practices, with comments. Next has been Krebs, Staff Attorney for Public First Law Center. Oh, I'm sorry, there you are. Go ahead, Ms. Park. Never mind. I thought you were in person. Go ahead.
Yeah, thank you. We had some comments on this. We think that the proviso would enable the boards to consider testimony, which typically doesn't come in until, 48 hours or so before the hearing. So this would enable the board members to be better prepared for meetings, to be able, when they can see the public testimony. Moving the deadline up to 2 business days might be a challenge for boards to get their meeting materials prepared in time for the board packets. It could also impede the board members' ability to fully review and consider what could be extensive reports and other materials. But that's really a policy decision up to the legislature. Although I would caution the legislature against really micromanaging the Sunshine Law through state statute. This is an example of how you have to keep amending the law because, it's becoming so detailed in its procedure, the statutory procedures, that whenever we see some kind of problem arise, we have to come back to the legislature to get the law fixed. So I'll be happy to answer any questions.
Thank you. Thanks for being here.
Thank you.
Next, Ben Krebs, Staff Attorney for Public First Law Center. Good morning.
Good morning. Ben Krebs, Public First Law Center. We stand in strong support of this bill. It proposes 2 small tweaks to the Sunshine Law that will help increase informed public participation. I'm available for any comments, and you have our written testimony.
Great, thank you. Next is Peter Fritz, by Zoom maybe, in support. Yvonne Lau.
No, I'm here, but
okay. Go ahead, Mr. Fritz.
Okay. I'm in strong support of this bill. Just the other day of changing it to 48 hours, just to 2 business days. Just the other day, there was a meeting notice that came out and it said that the packet would be available 48 hours, but 48 hours before the meeting was Saturday and Sunday. So there needs to be access, and the purpose of the board packets is to make information available. And if you can't get in before the meeting to see the information because it's a weekend, there's an issue. That's why I think that 2 business days is an appropriate standard. And I think if people had thought about this when this bill was first put into the law, that it probably would have been 2 business days. I've also been in a situation where I've been told the information for the board meeting is all on the website for the organization. And they give you a link to a directory, but there's no way to identify what documents are in the board packet. That's why I'm suggesting that when you get a notice that there's a board packet, that they should list the documents that are available. Some agencies do this, some agencies are not. But it does add to clarification, and that way people do not have to guess what documents are in the board packet because you're just a list of those documents. Thank you for the opportunity to testify.
Thank you very much. Thanks for being here. Next is Yvonne Lau for University of Hawaii Board of Regents with comments. Next is Sterling Marita, President for Hawaii Chapter of the Society of Professional Journalists in support. And that's that's everybody that's signed up for SB 2638. Does anyone else wish to testify on SB 2638? Seeing none, members, questions? Let's see if I've got anything here. I don't think I do. Let's go ahead and move on then. Next up is SB 2017. This requires defendants convicted of causing the death of a parent or legal guardian of a minor child by the operation of a vehicle in a negligent manner or while under the influence of drugs or alcohol to make restitution in the form of financial support to each surviving child of the victim. First up on 2017 is Tommy Johnson, Director, Department of Corrections and Rehabilitation. Comments? Okay, next is Ed Sniffen, Director, Department of Transportation. Good morning again. In support. Okay, thank you. Next is Alice Lena Liu, Programs Director from Mothers Against Drunk Driving, Hawaii. In support. Chelsea Gonzalez in support. Michael EKM Older in support. Dara Carlin in support. That's everybody who signed up on SB 2017. Is anyone else wish to testify on SB 2017? Seeing none. Members, questions?
Yes.
Senator San Buenaventura.
Thank you. So Director Sniffen, since you stand in support, and I don't know anybody else who's in support present here, my concern is limiting this bill to those who are 18 years of age or 19 if a child is still enrolled in high school. Do you have any problems with amending it to also include a disabled child regardless of age who is still dependent upon the victim?
That was convicted of OVUII? Is that?
Yes.
Yes, I have no problem.
Thank you.
Thank you.
Other questions?
My request is an amendment to include a disabled child. Thank you.
Other questions or concerns? All right, let's go. Thank you. We'll go ahead and move on to the next bill, which is SB 2193. SB 2193 amends the offense of use of a computer in the commission of a separate crime to include violation of privacy in the first and second degrees. First up on SB 2193 is Thomas Chang, Captain in Criminal Investigation Division for Honolulu Police Department. Oh, there you're on Zoom. Good morning.
Morning, Chair. My name is Thomas Chang. I'm the Captain of the Criminal Investigation Division. HPD stands by a written testimony. I'll be here to answer any of your questions. Thank you.
Great. Thank you. Next is Isla Weiss, Deputy Prosecuting Attorney for City and County. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the Senate Committee on Judiciary. Deputy Prosecuting Attorney Isla Weiss on behalf of the Department of the Prosecuting Attorney. I appreciate the opportunity to testify in SB 2193. The Department of the Prosecuting Attorney has submitted written testimony in strong support of SB 2193, which is a bill that is part of the Department's 2024 legislative bill package. Currently, the offense of use of a computer in the commission of a separate crime is only applicable to 9 specific offenses. The Department of the Prosecuting Attorney is proposing just 2 other offenses so that it would prohibit a person from knowingly using a computer to identify, select, procure, or alarm the victim of an intended victim of a VOP first or VOP second. The addition of VOP first or VOP second intends to narrowly criminalize when these perpetrators use computers to identify and procure future victims of these offenses. It is not intended to be redundant or add additional criminal penalties to behavior that is already criminalized. With respect to VOP first, for example, prior to the prevalence of computers, which is a generic term for cell phone, if a person wanted a copy of a person's private pictures, they would need to Xerox it or replicate it in some manner that was time consuming. With cell phones, a person can take a picture of a physical picture or take a picture of another phone containing these private pictures, thereby identifying and procuring many more potential victims of these crimes in a quick and subtle manner. This change would ensure that perpetrators who used their cell phones to take pictures of either private physical copies of photos or took advantage of a temporarily unlocked cell phone or had limited access into a cell phone, thereby then exploiting that to explore private areas of it, they would then be deterred from that type of behavior. Thank you for your time.
Thanks very much. Next is Victor Ramos in support and Dara Carlin in support. That's everybody who signed up to testify on SB 2193. Would anyone else like to testify on SB 2193? Seeing none, members, questions? I do have a question, I think, for prosecutors.
Yes.
So the offense of use of a computer in the commission of a separate crime acts as an enhancement for the underlying crime. So basically, the penalty is 1 grade or 1 class higher. The enhancement statute is limited to 9 specified crimes, which is the reason for this bill, which adds to that list. Would there be some? Would it make sense to have an overall, how to describe it, a general statute that enhances the penalty for any crime that's committed with a computer?
I don't believe that it would. I would be then, I think we would be open to concerns by, say, the public defenders or the general public that we are just adding enhancements to already established crimes. There's a lot of crimes that are readily inherent that you need a computer to commit them with. So
Okay,
in those
so you think
circumstances, then it would be duplicative.
Certain crimes have a nexus to computers and they should be, the punishment should be higher. In other crimes, you could do them with a computer, but it's not the same sort of enhancer that it would be.
Correct. For the crimes that already basically have the element of using a computer, it would just be an additional enhancement.
Okay.
Simply that was already built into the statute.
Okay.
These offenses don't necessarily require using a computer to commit them. So these enhancements are important, again, when they're using that computer to then secure their victims.
Okay, all right, thank you. Thank you very much.
Thank you.
Captain Chang, you still there?
Hey, Chair, still here.
So basically the same question as I posed to the deputy prosecutor. Would it make some sense to have an overall enhancement for any crime committed with a computer, or do you think there's only special crimes that deserve extra penalties because of the use of the computer?
Again, my opinion, I think just like what you said, yeah, there are certain crimes related to computers. So I agree with the prosecutor's office is saying.
Okay, all right, thanks very much. Members, other questions? If not, let's go ahead and move on to SB 2197 relating to gambling. It amends the definition of advanced gambling activity by deleting permits the activity to occur, and then it would delete or continue or makes no effort to prevent its occurrence or continuation. First up is Mark Tom, Deputy Attorney General. Or Trisha Nakamatsu, Deputy Attorney General. Good morning.
Good morning, Chair, Vice Chair, members of the committee, Deputy Attorney General Trisha Nakamatsu, appearing on behalf of the Department of the Attorney General. We are in support of this bill. We believe it would effectively close a loophole that currently exists when prosecuting defendants for promoting gambling in the first or second degree. Those are the statutes that are primarily used to prosecute illegal gambling establishments, which are a high priority for the department, and we understand for the legislature as well. The portion of the definition that would be amended is particularly key for prosecuting the real property owners or perhaps property managers, which is also going to be a priority, really trying to get to higher levels of these types of offenses rather than just the cashiers and security guards, people of those nature. Available for questions, if any.
Great, thank you.
Oh, I'm sorry, one last thing. We do think that the prosecutor will be suggesting a slight amendment to the bill to leave in the words "or continue" on page 2, line 7, and we would agree with that change, to leave it in.
Okay, so then
not delete it.
the end of that sentence would be permits that activity to occur or continue.
Correct.
Okay.
Thank you.
Okay, thank you. Next up is Gabriel Huntington, Deputy Prosecuting Attorney for, I'm sorry. Yes, that's right, Deputy Prosecuting Attorney for City and County. Good morning.
Good morning, Chair, Vice Chair, members. My name is Gabe Huntington, Deputy Prosecuting Attorney on behalf of the City and County of Honolulu. We are expressing our strong support for this. I would note the error that Ms. Nakamatsu pointed out, that we would like that corrected, so the language would end with "or continue." The preamble to the 2020 amendment states that game rooms contribute to murder, violence, and sex trafficking. And that the legislature made the specific finding that the existing law makes it impossible for law enforcement to prosecute property owners whose properties are used for illegal gambling houses. The language "or makes no effort to prevent or continue its continuation" provides a defense to property owners that the state could never overcome at trial. Should a defendant provide evidence of any efforts whatsoever, the court would be required to issue jury instruction to the effect of the burden is on the prosecution to disprove that the property owner took no efforts. We would never be able to disprove that they took no efforts. As a result, we could never prevail at trial. And as prosecutors, we have a duty not to charge cases that we can't prevail at trial. As such, we urge our strong support for the passage of this. I thank you, and I'll be available for questions.
Thank you. Next, we have Mike Lambert, Major Narcotics Vice Division for Honolulu Police Department in support, and Victor Ramos in support. That's everyone who signed up on SB 2190. Oh, I'm sorry, you're here.
I just want to say I'm Captain Jerome Buka with the Honolulu Police Department.
Please.
Narcotics Vice Division. We stand in our testimony to support.
In support, great, thank you. Would anyone else like to testify on SB 2197? Seeing none, members, questions?
Yes.
Senator Buenaventura.
Yes, thank you. Prosecutor. So I have to admit, I did not look at the actual statute, but looked only at the bill. Is it basically your request that this, by allowing for this amendment to the statute, that you would be able to prosecute the property owner who allows the gambling activity to occur?
Correct.
Because with civil asset forfeiture, you folks will be able to civilly acquire that property already, right? So this just gives you another method of prosecuting the owner.
It's not so much civil asset forfeiture. It's still difficult to make the connection between the owner and the activity for asset forfeiture purposes.
So I'm sorry.
What we can do is nuisance abatement, which can prevent them from using that. And that's a complicated process, and it takes a lot of time. Versus charging with a felony offense, it's more visible, and it gives them it gives us an opportunity to really chill gambling houses.
Okay. So again, I apologize because I'm a chair of another committee, a big committee, that I didn't actually look at the statute. If we allow for this amendment, what would the property owner who allows the gambling activity be charged with? A Class C, a Class B?
Class C, in most cases.
Class A?
C.
C.
So it'd be the PG2 promoting gambling setting.
Okay, thank you very much.
Thank you. Any other questions?
I don't know yet. Any other questions, members? Okay, I do have one. So I don't know, the wording which the testimony describes as a loophole has existed since the early 1970s. So
that's correct.
Was it interpreted differently before, or
so I went back.
Why has it taken all of us so long to figure this out?
My understanding reading the older language is that it is meant to reach, say, a bartender or somebody who's present at the scene at the time the offense is occurring, versus reaching a property owner who is allowing it to occur.
Okay, all right, that sort of makes sense.
So it would reach the cashier, but not the owner.
Okay, all right, I think that's it.
Yeah,
There's
I'm
other
sorry,
questions?
I do.
Senator Buenaventura, go ahead.
Okay, so I admit again, I didn't actually read the statute, and I've never defended somebody who was charged with advanced gambling activity. So please bear with me. So in the event we do this bill and we allow you to more easily prosecute the owner who allowed gambling activity to occur, will the owner have a defense of ignorance? Will you be allowed? Yeah.
The statute as written currently requires that they have knowledge that the property is being used for gambling activity. So they would.
So you're still going to be required to prove beyond a reasonable doubt the mens rea of knowledge.
That they knew it was there. The way I would imagine accomplishing this is we give them a nuisance abatement warning. We give them a reasonable amount of time to seize the gambling house activity. And then only then, if they are obstinate, do we take action.
Okay. I mean, that makes me feel better. Thank you. Because I'm concerned about like short-term vacation rental owners who don't know what their tenants are doing when.
Right.
Yeah.
Yeah, it does require actual knowledge.
Okay, thank you.
Any further questions?
You should be a committee chair. Any further questions, members? Seeing none, thank you very much.
Thank you.
I think, members, unless you want to take a recess, I'm ready to do some voting. Okay, we'll go ahead and start at the top of the agenda. SB 3174, this is relating to state tax administration. This eliminates an obsolete fee for a certified copy of a tax clearance, adds a penalty for failure to comply with reporting requirements in certain situations. Recommendation here is to pass with technical amendments only. Questions or concerns? If not, Vice Chair Gabbard.
Chair's recommendation is to pass SB 3174 with amendments. Chair Rhodes.
Aye.
Vice Chair votes aye. Senator Infante.
Aye.
Senator San Buenaventura.
Aye.
Senator Owa.
Aye.
Measure passes.
Thank you, members. Next up is SB 3008, proposing amendments to Article 7, Sections 12 and 13 of the Hawaii Constitution to expressly provide that the legislature may authorize the counties to issue tax increment bonds and to exclude tax increment bonds from determinations of the funded debt of the counties. Recommendation here is to go ahead and pass with some amendments. Hang on just a second. So I think we'll go ahead and use the language from the bill that we passed out of JDC last year, SB 1295, to clarify in the proposed constitutional amendment what is meant by tax increment bonds. So that's it's trying to find the best language for this situation. We think that's better, but it does go to another committee. So then it would read bonds, the principal and interest on which are payable from and secured solely by the amount of real property taxes levied and collected by a political subdivision such as a county on the difference between the assessed value of the taxable real property located within the boundaries of a tax increment district established by a political subdivision in a given year and the assessed value of the taxable real property in the tax increment district during the year of creation of that tax increment district. So that would be the big change. That would be the change. I think I'm going to recommend that we leave in the exclusion from the debt ceiling. You could, this looks sort of like, it's not a non-recourse bond, but there is a separate source of funding from it that normally should cover it. So I think it's probably okay to leave it as is, that portion of it. Questions or concerns? If not, Vice Chair.
Recommendation is to pass SB 3008 with amendments. With all members present, are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is SB 3029. This is claims against the state. Recommendation here is to pass with some amendments. We'll accept the AG's amendment to correct an error of the civil trial identification for Rodney Pogba versus Ann Lopez on page 3, line 1 through 19 of the bill. In section 2, we'll add a proviso to Courtney Ledford versus Ethan Ferguson, such that of the total claim of $1.25 million, 20% or $250,000 shall be payable from the Department of Human Resources Services Administration Program ID, and a further 20% or $250,000 shall be payable from the Department of Land and Natural Resources. In section 2, we'll add a proviso to Lynette Reyes versus Eric Tanaka that of the total claim of $2 million, 40% or $800,000 should be payable from the Department of Public Safety Administration, and the remainder of the claims in the general fund be appropriated to the Attorney General. That's it. Is that it? That's it. Questions or concerns? If not, Vice Chair.
The Chair's recommendation is to pass SB 3029 with amendments. With all members present, any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is SB 2638. This requires boards to make available for public inspection board packets, if created, at the time the board packet is distributed to the board members, but no later than 2 business days before the meeting. Carves out an exception by allowing public testimony to be distributed to board members within 2 days before the meeting. Recommendation is to partially accept one of the amendments proposed by Mr. Fritz in his written testimony to require that when a board provides notice pursuant to section 92-7E, such notice shall include a list of the documents that were compiled by the board and distributed to board members before a meeting for use in the meeting. Will require that the board shall post board packets on their websites. Will keep the current requirement that boards accommodate requests for electronic access to the board packet. So if for some reason the person with the disability can't use the website, they can still ask for that the board accommodate the request for the electronic access to the board packet. Questions or concerns? If not, Vice Chair.
Recommendations to pass SB 2638 with amendments. Members present, are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is SB 2017 relating to financial support of a child after driving under the influence. It requires defendants convicted of causing the death of a parent or legal guardian of a minor child by the operation of a vehicle in a negligent manner while under the influence of drugs or alcohol to make restitution in the form of financial support to each surviving child of the victim. Recommendation is to go ahead and pass with some amendments. We'll accept Senator San Buenaventura's amendment that we include, so if I'm phrasing it right, adult dependent children with disabilities. Was that the phraseology?
Thank you.
Okay. And then we'll also remove the child's accustomed standard of living from the factors to be considered when the court determines the restitution amount. Questions or concerns? If not, Vice Chair.
Chair's recommendation is to pass SB 2017 with amendments. Members present, any no votes or reservations? Hearing none, the measure passes.
Thank you very much. Next up is SB 2193, amends the offense of use of computer in the commission of a separate crime to include violations of privacy in the first and second degrees. The recommendation here is to put in a savings clause, and that would be it. Questions or concerns? If not, Vice Chair.
Chair's recommendation is to pass SB 2193 with amendment. Any members present, any no votes or reservations? Hearing none, the measure passes.
Thank you, members. Next up is SB 2197. This amends the definition of advanced gambling activity. The recommendation here is to pass with the amendment recommended by the city. Right. I forgot who recommended. AG and the prosecutor's office, I believe, both agreed on this. So it will read, this last phrase will read, having substantial proprietary control or other authoritative control over premises being used with the person's knowledge for purposes of gambling activity, permit that activity to occur or continue. So we'll stop at continue or delete the next line and a half. They asked for the word or continue, or the words or continue to be included, and that's amenable to me. I believe that's the only change. Yeah. Questions or concerns? If not, Vice Chair.
Chair's recommendation is to pass SB 2197 with amendments. Of the members present, any no votes or reservations? Hearing none, the measure passes.
Thank you very much. That concludes our business. We're adjourned, and we'll see you Tuesday.